matter of Banca Intesa Sanpaolo SPA and another, and Comune di Venezia.
Yes.
My lords, my lady, may I begin with one loose end from yesterday, arising from some exchanges I had with my Lady Justice Falk and with the Chancellor, about whether our wider proposition would also include a change of position defence in the case of ultra vires payments by a private body.
Yeah, I don't seem to be running yet.
Real time.
No, it's not running real time. Why oh why do they not check this at the beginning of each day? Do we know has anybody got a contact for Opus? Find out what's going on.
I think it's being checked, my lord.
Well, we just have to start and not have it.
Great, my lord. The point I was on was the question raised yesterday about whether our wider proposition would also preclude a change of position defence in the case of ultra vires payments by a private body as opposed to a public body. This question was raised at page 153 of yesterday's transcript, lines 8 to 19.
Yeah.
If I may just make two brief points on this before moving on. First, whilst, as I did yesterday, I accept that the logic of our submission would also be engaged in the private ultra vires context, in my submission the outcome of the analysis would not necessarily be the same, because it may be that as a matter of common law, the ultra vires principle in a private context is not regarded as the type of public policy which engages the stultification principle. And one sees that distinction drawn in the estoppel authorities, that is to say, a distinction between the impact of ultra vires on the availability of an estoppel defence in the private context as opposed to the public body context. My lordships know the judge himself cites some dicta on this, at paragraph 363 sub 5.
363.
Yes. Proposing to take your lordships to it unless that would be of assistance. This is in the context of the judge rejecting an estoppel defence raised by the banks in these proceedings. If your lordships would like to look at that, that's at page 292 of the core bundle. Internal page 117 of the judgment. That's the first reference, and there the judge is referring to cases involving public bodies specifically.
Sorry, was that 362?
That is, my apologies, my lady, 363. First of all, subparagraph 1.
Oh, right.
There's several references in this passage of the judge's reasoning that I wanted to show your lordships. The first is sub 1, where the judge refers to Ryle. And then in sub 5 over the page,
Real, I think it is.
real, fine. Your lordship's quite right, real. And then over the page, sub 5, Mr Justice Tomlinson's treatment of real in Haugesund. And it's the last sentence where Mr Justice Tomlinson refers to statement of Harmon J in real, where a distinction is drawn potentially between the availability of the estoppel defence in the private and public contexts.
Yeah.
And then the final reference on this is in 368 sub 1. This is a reference to Mr Justice Cockrell's judgment in Tuesday, where Mrs Justice Cockrell is considering judgment of Andrew Smith J in Vestia, and there she points out that a relevant point of distinction, this is Mr Justice Foxton's summary of what Mr Justice Cockrell held, is that Vestia was a private and not a public entity.
Yeah.
That was the first of my 2 points, that in the estoppel context, at any rate, a distinction does appear to be drawn in the authorities. And the second is that it may be in our submission that the issue is not one which would commonly arise in this jurisdiction in practice as regards public bodies. And the reason for that is because in the case of companies registered under the Companies Act 2006, there is a statutory abrogation of the ultra vires principle, at least insofar as it relates to the relations between the company and third parties. And that is section 39 of the Companies Act 2006. I wasn't proposing to place this in the authorities bundle, but I can simply read the wording of it into the transcript if that would be of assistance. It may be very familiar to your lordships. Section 39 provides that the validity of an act done by a company shall not be called into question on the ground of lack of capacity by reason of anything in the company's constitution. And that is treated as a statutory abrogation of ultra vires in the private context.
For UK.
For UK registered companies, I accept that's a limitation to this exception that I'm this distinction I've got. So, my lords, yesterday I showed your lordships some authorities on the stultification principle. May I now turn to the ultra vires policy, which is the public policy which we submit, engages the stultification principle in this case. And by way of reminder, our primary submission is that the ultra vires principle is a policy of English law that would be stultified by permitting the retention of benefits transferred under an ultra vires contract by way of a change of position defence. And I'll be showing your lordship some dicta from a couple of authorities, but before I do, might I just summarise the 3 points which we seek to draw from those authorities. And the first is that the ultra vires policy is regarded by English law as relevant to the availability of restitutionary claims and defences, just as it is regarded as relevant to the availability of a defence by way of estoppel. And this is a response to a submission made by my learned friends at paragraph 60 of their skeleton argument. And the submission is that once the ultra vires doctrine has resulted in a contract being declared void, its purpose is exhausted, and as we understand the submission, it's submitted that it has no continuing relevance on the availability of remedies in the law of restitution. And we submit that is both inconsistent with the estoppel example, but it's also not borne out, we submit, by some statements in restitution cases, which I'll show your lordships.
Sorry, which paragraph is that, skeleton?
Paragraph 60 of their skeleton, page 169.
Oh yeah, okay. Yep.
The second point from these authorities is as follows. Outside the hedging context, there is further first instance authority in which the ultra vires principle has been held to preclude a defence of change of position following Svenska. So the point I'll show your lordships is that the context in which this has arisen is not only limited to hedging, and there is at least one other context in which a first instance judge has followed the approach taken by Mr Justice Clark in Svenska. And then the third point I'll be making is that none of the authorities relied on by my learned friends as to the availability of a change of position defence in an ultra vires context, we submit provide adequate support for that proposition. And the authorities relied on by my learned friends are in substance those relied on by Goff and Jones on this point. So my lords, turning then to the ultra vires principle, may I start by giving your lordships some references for two propositions which are not understood to be controversial, and therefore I don't propose to show your lordships any authority on them. And the first is that the ultra vires principle exists for the protection of the public. If your lordships note, one sees that from Hazel in the speech of Lord Templeman, at page 36C to G of the report, which my lords have at tab 21.
Do you want us to look at that?
No, my lord, it's not understood to be disputed, so I was simply giving your lordship the reference.
Right.
And that's at page 658 of the authority bundle. So, and the reason I'm summarising these propositions is because they are context for my submissions, but in my submission I don't need to show your lordship the authorities to make them good because they're not understood to be controversial. And the second is the proposition that a party cannot raise an estoppel defence, whether by representation, common assumption or contractual estoppel, where doing so involves reliance on an invalid ultra vires act. And we set out the authorities on this at paragraph 65 to 68 of our skeleton argument. I wasn't proposing to take your lordships to the estoppel authorities, they're well known, Real and Matthews.
Yeah.
And your lordships will have in mind our submission that the rationale for precluding a defence in that context lies equally in the change of position context. So, can I then please turn, my lords, to a dictum in a restitution case on which we rely? And this is the case of Kleinworth, Benson and Birmingham in the Court of Appeal, which your lordships have at tab 29 of the authorities bundle. Page 1042 of the electronic authorities bundle.
Will give me the 29.
Tab 29, my lord.
No.
This was a case which held that the defence of passing on was not available to a local authority. In a claim for restitution brought by a bank, and the basis for the defence, or suggested defence of passing on, were hedging swaps entered into by the bank, which the local authority contended meant that the banks had suffered no loss, in essence because the bank had received payments under the hedging swaps, equivalent to those it had paid to the local authority.
Right.
And the defence of passing on was rejected for a number of reasons. Lord Justice Evans and Lord Justice Morritt each gave judgments rejecting it, and Lord Justice Saville agreed with both judgments. But the dictum I wanted to show your lordships is in the judgment of Lord Justice Morritt, and that is at page 1062 of the electronic authorities bundle. It should be page 400 of the report.
Give me the paper reference.
In the hard copy, it's page 1056. And it's page 400 of the report.
Hang on, something's gone wrong. Quite know what's happening.
I'm proceeding on the basis that the electronic authorities bundle is 6 pages ahead of the hard copy. If that's not
Yeah, no,
correct,
I'm
then
sorry,
do
Mr.
please tell me.
Paul. No, it's my incompetence because I reeled on beyond that case into something else, and so I was looking at the wrong. It's page 400 of the authority.
It's the sidelined passage at H on page 400.
Yeah.
If I could invite your lordships, please, to read that once you have it.
Yep. Got it.
context for this, where you are concerned with a passing on defence, has nothing to do with change of position, does it?
That's not my submission, my lord. It doesn't. And as I submitted, the passing on defence was rejected for a number of other reasons. But the point I'm making by reference to this authority is that Lord Justice Morit regarded the impact of the ultra vires doctrine as one of the reasons why a passing on defence should not be available. It's really in his words, all those factors which go to establish the case for restitution. That's a reference back to the first sentence, the void swap, the ultra vires and void swap, would be nullified or undermined by a defence of passing on.
It's just that passage, is it?
It's just that passage that I wanted to refer your lordships to. It's May I then please show your lordships a similar dictum in the House of Lords authority. And again, I'm not going to be relying on this for any more than the proposition that the ultra vires principle has been treated as relevant in a restitution context, different in the context of different issues, as to the availability of a change or of a claim or defence. This is Claimants, Benson and Lincoln,
Right.
which your lordships have at tab 31 of the authorities bundle. The passage I wanted to show your lordships is at page 1198 of the hard copy, or 1204 of the electronic. It's in the speech of Lord Hope. Once your lordships have that, it's should be page 415 of the report. 1198 of the hard copy, 1204 of the electronic.
Yeah, okay.
And this is the case which established the proposition that a restitutionary claim arises in respect of a right to recover money paid under a mistake of law. So again, I'm not submitting that this case dealt with change of position, but what I am submitting is in this passage, in particular at page 415 D to E, Lord Hope places reliance on the ultra vires doctrine in rejecting an argument made in that case. And the argument to which Lord Hope was responding was the submission that was the question of whether the fact that the swaps in that case were fully performed should prevent recovery via a restitutionary claim. This was an argument made by the local authority in that case. And in my submission, as your lordships will see from that passage, Lord Hope places reliance on the fact that not permitting such a restitutionary claim would be inconsistent with the ultra vires policy. It would, in his words, be giving practical effect to a transaction which on the doctrine of ultra vires did not legally exist. And that is all I wanted to show your lordships in that authority. The next, perhaps I can just tell your lordships about it rather than take your lordships to it. This is the Hinckley case. This is in the next tab in the authorities bundle.
Sorry, which case?
Hinckley and Bosworth Borough Council and Shaw. This is a first instance judgment, Mr Justice Bell.
Oh yeah.
And this is at tab 32, page 1206 of the electronic authorities bundle.
Yeah.
And this is a case in which,
I think it is.
my apologies.
Hinckley is 1208 of you.
1208, my mental arithmetic failed me. My apologies.
Thank you very much.
Yes, so this was a case in which the judge rejected a change of position defence based on the ultra vires principle we submit, applying the reasoning in Svenska in a different context. So the case involved an ultra vires agreement between an employee and a council in the context of a redundancy. The council brought an action to recover sums paid pursuant to that ultra vires agreement, and the employee relied on a change of position defence. And the relevant passage is at page 50 of the report, which is at page 1249 of the electronic bundle.
Page 50.
Page 50 of the report, page 1249 of the electronic authorities bundle. And it's from page 50, little f, to the top of page 51. And the reason I'm referring to your lordships to this is simply because it's an example of a case in another context in which a first instance judge has followed Clark J's reasoning in Svenska and applied it to his case.
Yeah. Okay.
So, my lords, those are the authorities we rely on. May I now please address the authorities relied on by the banks in support of the availability of a change of position defence in ultra vires cases, putting to one side, of course, the judge's judgment for the moment. And for my lordship's note, those are the authorities of paragraph 62 of my learned friend's skeleton argument.
Yeah.
There are three, that is to say, Eastbourne, Charlestown and Haugesund. And in the interest of time, I wasn't proposing to take your lordships to these authorities unless that would be of assistance. I was instead proposing to tell your lordships why we submit they aren't of assistance to my learned friends, and then if necessary come back to them in reply. The first is Eastbourne, which is at tab 36 of the authorities bundle.
Well, either you
Page
want
one.
us to look at them or you don't.
I wasn't proposing to take you to, my lord. I was simply giving a reference, but instead, perhaps I'll just summarise what we say about them, and then if my learned friend wants to show them to you, come back to them.
Yeah.
So we have three short points to make on this judgment. The first is that the issues before the Court of Appeal didn't include any issue concerning the availability of a change of position defence. It seems that defence had succeeded below, but we don't have the first instance judgment, and we're not told in the Court of Appeal judgment why the defence succeeded or what arguments were made. One sees that at paragraph 20 of the judgment. The second point we make on this is that Svenska was cited to Lord Justice Ricks in this case, in the Court of Appeal, which concerned a different issue, not change of position. In the context of addressing that issue, Lord Justice Ricks did not disapprove of Svenska. And thirdly, we say that Lord Justice Ricks' overall conclusion in this case, which was not about change of position, but about the extent to which there was any legal relevance of acts undertaken pursuant to an ultra vires agreement. And just if I could summarise it very shortly, what Lord Justice Riggs held was that acts undertaken in purported performance of an ultra vires agreement amounted to an acceptance and repudiation of an earlier valid agreement. And our submission is that in reaching that conclusion, Lord Justice Riggs was careful to ensure, in his words, that it did justice to the facts that occurred and to the doctrine of ultra vires. And that is at paragraph 35 of the report. So we submit it's not on point, it's not addressing change of position, but in any event there are indications consistent with our submission. The next is Charles Terence Estates, and I can take this very briefly, my lords, because this was a case in which an anticipatory change of position defence was allowed in response to a restitutionary claim by a local authority. So it is a case inconsistent with our submissions, but there was no consideration in the case of the relationship between that defence and the ultra vires policy. The change of position defence was opposed on wrongdoer grounds which failed on the facts. And so there was no citation of Svenska and no consideration of the arguments we are making. My lords will see that from paragraphs 97 to 99. Finally, my lord, there is Haugesund. And Haugesund was a case in which some arguments based on public policy were made. However, in our submission, they arose in a different context, which does not assist your lordships. In Haugesund, the public policy argument was that permitting restitution of benefits conferred pursuant to an ultra vires agreement would be contrary to Norwegian public policy. And that argument failed, including because of the absence of any relevant evidence of the Norwegian statutory policy. And with our submission, that is a different context, and it's important because there can be no question in our submission that a claim to reverse benefits transferred ultra vires would stultify the ultra vires policy, or could be regarded as giving effect to indirectly to the ultra vires contract, because of course the premise of such a claim is the reversal of benefits transferred ultra vires. And that we submit is an important distinction. Now it's also right to note, as my learned friends do, and they place reliance on this, that a change of position defence was advanced in Haugesund, and it was rejected for other reasons. But again, the point we are taking does not appear to have been argued in that context. So whilst there is an assumption that a change of position defence would have been available, there is no argument on the point at any rate as regards ground 2A of our appeal. So my lords, that is what we say about the authorities relied on by my learned friends. Now just to conclude my submissions on ground 2A, may I just summarise briefly why, in light of the authorities, which I've shown my lords, we say the judge erred in law in his conclusion at paragraph 424 of the judgment, that the bank should be entitled to raise a defence of change of position in respect of payments made under the hedging swaps. And I'll just summarise very briefly in two points why we say the judge erred. And all this is prefaced by the observation, my lords, which we made in our skeleton, that on this issue the judge had very little assistance at all from the parties. It was dealt with in a matter of paragraphs by both parties of written submissions, and as I recall, it wasn't addressed in oral closing. And so the two reasons, my lords, why we say if our analysis of the authorities is correct, the judge erred. First of all, if we are right that the ultra vires doctrine precludes a change of position defence on stultification grounds, then it necessarily follows that the judge erred. So if our wider proposition is accepted, then the judge was necessarily in error. Secondly, whether or not our wider proposition is accepted, we submit the judge erred in not following Svenska, and in particular for two reasons. First, we submit the judge wrongly treated Svenska as having been superseded by the recognition of a defence of anticipatory change of reliance. By the Privy Council in Dextra and the Court of Appeal in Jones and Commerce Bank. The judge provides the relevant citations at paragraphs 406 to 408 of his judgment. However, we submit neither of those cases were void ultra vires cases, and it's notable, as appears from the citation from Dextra at 407 of the judge's judgment, that the Privy Council did not disapprove of Svenska and Dextra, but instead treated it as a case on exceptional facts. So that was the first of those 2 points. We say the judge wrongly treated Svenska as having been superseded by the allowance of anticipatory change of position in Dextra and Commerce Bank.
But it's quite a polite way of saying that they thought that it was wrongly decided. And that's how a Privy Council would normally approach an English law authority, because technically it couldn't overrule it. If it had been the Supreme Court, I suspect they'd simply said it was wrongly decided.
I see the point, my lord. But what is clear is that they
When you
don't
say
say...
it depended on the exceptional facts of that case, it's tantamount to saying, well, either it was wrongly decided or it's limited to its own exceptional facts, which won't be repeated in a later case.
I accept that, my lord, but there's no indication as to what those exceptional facts were. And I quite take my lord's point, that would be an unusual way for the Privy Council to express its conclusions if the exceptional facts were perhaps as broad as we say they were, namely the ultra vires void contract context.
Yep.
But it may be that there is a narrower, perhaps a narrower way of looking at the facts of Svenska, which nonetheless is still relevant on the alternative way we put our case, which is that what was exceptional about Svenska is that it did involve reliance on the assumed validity of a void contract. Whereas in other anticipatory reliance cases, it may be more easy to see that one is relying on the expectation of a specific payment. And this is the contextual point I made at the start. When one is dealing with swaps and hedges, that analysis, in my submission, is less clear because of the indeterminate nature of the benefits one will be receiving under the swap. And I think I've covered what was going to be my final point there, which is that we say, in any event, the judge erred in not recognising that allowing a change of position defence in these circumstances would involve reliance upon the assumed validity of an ultra vires contract. And just as that type of reliance is prohibited by the ultra vires doctrine in estoppel cases, we submit that it is prohibited in change of position cases as well, for the same reasons. So unless I can assist your lordships further, those are our submissions on ground two.
What would you say if the position was the other way round, so that it was Venice who had been in the money,
Yes.
and the banks were making a claim that the contract was void for lack of capacity, and they wanted their money back? Would you say that even though Venice had spent the money over and above what was needed to service the bond on providing public services, the residents of Venice would have to stump up?
Yes, we would, my lord, because our submission is that the policy, which would be contravened by allowing a change of position defence in that context, is the same as arises in this context, namely that transfer of benefits conferred ultra vires should be reversed. And I have to accept that would, on the logic of our submission, apply in both directions.
I see. Thank you.
Okay, good. Thank you very much, Mr. Paul. Yes, Mr.
If it please you, my lord, lady, I now will address the final point in relation to our appeal, which is essentially I've got it, risk-taking point, and your lordships will have seen it in our skeleton at paragraph 77 and following. And just to introduce this, essentially the judge found that the defence of change of position was available in principle to the banks based upon the back-to-back swap agreements that they had entered into following the agreements that they made with us. And essentially we submit that the judge should have followed the Westdeutsche approach of Mr Justice Hobhouse as he was, and decided that in principle on these facts that defence of change of position was not available to the banks. What I'm proposing to do is just to show you the authorities that we refer to, and then draw them together, and then deal with a couple of points made by my learned friend in her skeleton. May I start, please, by asking you to look at Goss and Chilcott, which is in tab 96 of the authorities bundle, which is volume 13, decision of the Privy Council. And page 5294. The finance company had advanced monies to the defendant on a mortgage. The defendants lent the monies to a related third party who was supposed to repay the finance company but didn't. And there was a claim in restitution and a defence of change of position relied upon. And if I can ask you, please, page 799 in the report, which is 5305 printed, 5311 in the digital. And if I could ask you, please, to look at the paragraph starting from the beginning at C. Perhaps read that to yourselves. So from this we draw two main points. Firstly, that the decision of the Privy Council was based upon the point that the defendants had taken the risk in paying the third party, that they would have to pay the finance company if the third party didn't. And that's really at letter D. They had, therefore, in allowing the money to be paid out to Mr Haddon, who was the third party, deliberately taken the risk he would be unable to repay the money, in which event they themselves would have to repay it without recourse to him. The second is that with every respect to the speech of Lord Gough here, it isn't spelled out exactly why that is. It is clear that for the defence of change of position, it is not enough in the circumstances which happened in this case to be able to rely on the fact you've paid out the money and can't get it back. And it could, and we'll see this in later cases, it could be put either on the basis that the original payment to the defendants hadn't caused the change of position. There was an insufficient link between the one and the other, or it could be on the point that it's unjust. And one does see in that connection, in the third last line of the paragraph, in the circumstances, so the fact they cannot now obtain reimbursement doesn't render it inequitable for them to be required to make restitution.
What exactly is the risk that you say the banks were taking here? Because on the face of it, taking out hedging contracts is the very opposite of risk taking.
It's to some or greater extent designed to protect you from the risk of non-payment by the.
So what's the risk? What's the risk that the banks were taking in our case?
I will address that, my lord. I just misspoke there. It's from the risk of market movements, meaning that you're out of the money on the inward swap. That's the purpose of the hedging swap. The risk that the banks took was that under whatever terms they negotiated for the outward swaps, and we don't have that in evidence, and we don't know that yet, that there might be circumstances in which they didn't get paid matching amounts on the inwards. Apart from anything else, there's the obvious credit risk. And if Venice were unable to pay for whatever reason, it became illegal to pay for whatever reason.
But those are all points that come out on the quantum hearing, don't they? I mean, the judges only dealt with as a matter of principle.
Well, my lord, they would.
Rather like my lord, I'm puzzled by the reliance on these cases like Goss and Chilcot in circumstances where the bank what the bank's actually done is to seek to protect itself rather than reverse.
Well, my lord, these points may well come out on,
Well, they may,
on the
I mean,
quantum.
well, obviously, if it turns out that they don't get under their hedging swaps, they don't match in some way, well then of course the change of position defence will fail to that extent. But
Yes, my lord, and that is certainly a live point in the quantum, but it's also very relevant in my submission to this primary question about whether or not in principle it's available in circumstances where the bank has chosen to obtain a hedging swap.
If I've understood you, the risk you're identifying in this case is a risk of not receiving payments from Venice. And you say the banks took that. That is a very, very different risk to the sort of risk being considered in Goss and Chilcot.
It is very different. Absolutely, I'm not disputing that the facts of Goss and Chilcot are very different.
Yes.
The vital question for your lordships in my submission is this one about who's taking the risk here. If payments are made by Venice, which in principle it's entitled to recover, that the banks may choose, as they have, foreseeably, as the judge has held, to go out and seek protection for themselves against the risk of non-payment by Venice under those swaps. That's the vital question, and I don't want to. I would like to go through these other authorities, but just to address upfront this point, our submission is essentially that it was a choice for the banks to do what they did. Yes, foreseeable, but it was a choice. And the terms on which they chose to hedge were a choice. And yes, that may go to quantum in the end, but it also goes to who should bear the risk of the non-payment in the circumstances which have happened in this case. In principle, those terms will cover not just the extent of the outward protection, not just the length of it or the level of protection, but also what risks are to be covered. So we don't know if the banks in this case had in mind the possibility that the inwards might be rendered void for whatever reason. But it's always open to a counterparty who is choosing.
I'm sorry to stop you, but you can see from what's going on, because Stu are obviously having problems picking up what you're saying, which is critical because the information I've just had from my clerk is that they have been unable to resolve whatever the problem is with the feed. There's a block on the feed.
I can see that, my
kind,
lord, yes.
but they are transcribing, which is the important thing. But obviously, if they can't hear what you're saying, they won't be able to do either, and we won't have seen it on the screen. So
I'm so sorry.
just see if you can. It's not your fault, Mr. Cox. I said to you earlier. There's a curious sort of lacuna in the courtroom over there.
I mean, the Bermuda Triangle.
See if you can just sort of.
I'll try and raise my voice, my lord.
Yeah.
Yes, I was just coming back to the fundamentals of it, of the situation as we see it, and it is, and I do want to progress through the authorities. It won't take that long, but it's very important to our case that here the banks ultimately did have the choice to go out and get outwards swap protection, and on what terms. And that doesn't just go to quantum, it goes to ultimately who it is who should, it goes ultimately to whether the bank should be able to say, we do not have to repay the money, which in principle they do have to repay, because what we did was sufficiently linked to the payment you made. And it
might be said that in many cases where the change of position defence succeeds, the defendant has a choice. What the defendant does in reliance on the understanding that the transactions are valid transactions in this case.
Yes.
The bank had a choice, but the fact that it had a choice surely doesn't negative the reliance, does it?
Well, my lord,
isn't that the difficulty with this argument?
Well, my lord, no, my lord. It had the choice to.
And Goss and Chilcott's different because in Goss and Chilcott, they paid the money away to I think the wife's brother, from recollection.
Yes.
In circumstances where they knew that one way or another they were always going to have to repay the money.
Yes.
So that was the context, and these kinds of transactions are completely different.
Well, my lord, no.
The bank never knew it would have to repay the money.
Well, my lord, in my respectful submission, no, because the banks knew that when they took out those outwards hedging swaps, if for any reason they did not receive the payments under the inward swaps, for any reason, then they would still have to pay on the outward swaps, just as in Goss and Chilcott. The defendants knew they'd still have to pay on the mortgage.
Okay, all right.
My lord, if I may, I'll come back to this once I've just finished addressing these other authorities. Haugesund, tab 49, page 2691. That's 47 in the bundles. And so in this case, as your lordships know, there was there were swaps between the communes, the local authorities in Norway, and the banks, which were held to be void. And the banks claimed restitution of upfront payments they'd made to the communes.
Yeah.
And the question was whether or not the communes could rely on change of position. And the paragraph, page 2691, paragraph 6, towards the bottom there, your lordships will see that what had happened was that the communes had invested those the sums they had received and had suffered a considerable loss on those investments.
Yeah.
And then at paragraph 123 in the judgment of Lord Justice Aikens, which is page 2724 printed, 2730. Lord Justice Aikens, having analysed the authorities, I've concluded, well, if I can ask you just to read that paragraph. And then if you would, over the page, paragraphs 125 and 126. So what we would draw from this, my lord, is that firstly, although the communes, but for the payments by the banks, wouldn't have made the investments, that wasn't enough for them to establish the change of position defence. The in 126, the judge asked, well, where lies the justice of the case? And that is the approach here to this question. So it's being put on grounds of inequitable. And the second point is that in this case, the communes took the risk. You see that in the second last line of paragraph 125, in deciding to invest. They knew they'd have to pay back anyway, whether the investments went up or down, and here they went down. And then, if I may, if I could ask you to look at the Westdeutsche case, which is in tab 26 in your bundles. Which is bundle 3, if you're looking printed. I don't think any of you are. And so I'm just trying to find the beginning of it. Yeah, so that's 904, printed 910. And this was one of the many cases in the 1980s and 90s where the swaps with local authorities were held void. The local authority claimed that the monies that were paid in restitution, and the bank relied on change of position based on various hedging swaps. And if I could ask you to look at page 946 in the report, which is 960 in printed 966, you'll see that the judge begins to deal with the topic of change of position, and at page 948 in the report deals with the defence in relation to one of the banks, which is all that we need for current purposes. And in the first main paragraph refers to the evidence that there was about the outwards swaps entered into by the bank. And in the very last sentence of that paragraph, the judge says that the reliance of Westdeutsche upon the defence change of position is misconceived, and then he makes a number of points. The relevant point is the one at the second point in the following paragraph. Secondly,
Sorry, I think I'm in the wrong place. You're at page 948 of the report.
yes, and at the very bottom paragraph, my lady.
Oh, I'm sorry.
No, sorry, I haven't made it clear enough. So it begins, the very bottom paragraph, and the relevant portion is the bit beginning secondly to the end of the page. And the contract with Morgan Grenfell is the outward swap. So what we draw from this is a very clear decision of Mr Justice Hobhouse, rejecting the change of position in relation to the outwards swap that was entered into in this case. It's put on the basis that there's been no change of position of Westdeutsche which is relevant to any claim which Islington might have made against it. I will draw these points together at the end, but can I just go through the remaining few cases? The next one is paragraph 20, is tab 27, South Tyneside, which is same volume. Tab 27 is judgment of Mr Justice Clark.
This is Svenska.
Svenska.
Yes.
Okay. Which paragraph do you want to go to? Page?
So in I could ask you to look at page 559 in the report. 1000 into 1006. One sees at the bottom of the page a reference to position there. There was a hedging contract with Morgan Grenfell, and there are references there to the differences between the inwards and the outwards, but in my submission they didn't have any significance in this case. But if you want to be aware of them, that's where they are. And it's 565 in the report. Letter E, Mr Justice Clark says bank is not entitled to rely upon the underlying validity of the transaction, either in support of a plea of estoppel or the defence of change of position. This is because the transaction is ultra vires and void. It's for this reason that in a case of this kind, the defence of change of position is in principle confined to changes which take place after receipt of the money. And then for those reasons, I agree with the second reason given by Hobhouse J. So I refer you to this because this case is referred to by the judge in his judgment, as we will see. Our appeal is not based on the point I'm dealing with. Isn't based on the ultra vires point. It's based on essentially the banks having taken the risk in taking these outward swaps. And about that, nothing more is said here. So I just wanted to point that out.
Sorry, which paragraph of the judgment?
E, page
Sorry,
5.
which paragraph of Foxton J's judgment?
411. Just get it out. That's the, yes, so 404 he refers to Westdeutsche, which we just looked at, and South Tyneside and Svenska. And then 411 is where he addresses the argument. So I just wanted you to see that. It doesn't contain reasoning which is relevant to the point I'm making. And then,
Is there anything wrong with the reasoning in 411?
my lord, yes, if I may, I'll just draw the points together from the authorities and then I'll deal with my submission. The final matter I wanted just to refer you to is Goff and Jones on this, which is in tab 124. Which is volume 15. And at page 6202, printed 6208, the editors refer to causation in relation to change position and the but-for test. And your lordships will see the last paragraph on that page 6202. The defendant must, at least on a but-for basis, prove at least on a but-for basis his change of position was causally linked. And then in the next paragraph, 27-33, if I could just invite you to read that. And what I would say about that, my lords, is that there the editors are putting forward the decision in Westdeutsche as possibly being based on a limitation to causation. It's not just but-for, but there's a remoteness element to it. As we've seen, another way of looking at this issue is unjustness. It's not unjust for the restitution to take place without any change of position having occurred. It's fair to say it hasn't yet been worked out in the authorities, and in my submission, for my purposes, it doesn't matter under which head the point is put. The question is whether there's a point. Now, the judge's judgment, which I just showed you, the essence of it is in paragraph 411 to 413. We could go back to that, my lords. And what the judge does is to address our submission, which is that there was no change of position defence. Firstly, by addressing the decision to take the obtain outwards protection, and it was a decision taken in anticipation of the fact that in the same market conditions as the inward swap, the bank would receive a largely equivalent payment from its counterparty. And he says, adopting the language of Dextra, it's surely no abuse that the defendant has, of language to say that the defendant has incurred the expenditure in reliance on the plaintiff's payment. He then quotes the summary of the change of position defence in Lord Burroughs' book, and at 413, I can find nothing in that summary which would deny the banks a change of position case. Indeed, the routine and objectively foreseeable nature of that anticipatory reliance and its back-to-back nature would seem to make this a paradigm case. Now, our first submission...
Doesn't that finding mean that if it is a matter of remoteness, then the judge has simply made different findings of fact, perhaps in different market conditions and understanding from that which Mr Justice Hophouse made some decades earlier?
Well, my lord, we would say no, because the points on which Mr Justice Hophouse was relying inevitably arise, we would say, in relation to any decision to obtain outwards protection.
I don't see that at all. Justice Hophouse wasn't purporting to lay down some universal principle. He was just saying on the facts of that case that the hedging arrangement was no more than or rather the first swap was no more than the motive of the hedging arrangement. And this judge has said in terms that it was routine and objectively foreseeable nature of the anticipated reliance.
Lord, yes.
And it may be that the world has moved on in the 30 years since West Deutsche.
My lord, it certainly has. And I'm not taking issue with routine or objectively foreseeable. Our opposition isn't, our appeal isn't based on that point. We of course would say that Mr Justice Hophouse, with respect, was quite right to say that the motive was the inwards swap. But the point, in essence, the point that the choice to make to obtain the outwards swap protection is for the bank in this case, is a complete answer to the change of to the use of the change of position defence in our submission, and it's one that therefore the judge ought to have taken into account. It was an error in our submission not to recognise that it could. I'm so sorry, my lady.
You finish.
Well, I mean, that is the error. The error is in not accepting our proposition that where it's the choice of the bank, as it always is in these cases, to go and get outwards protection, that means that there cannot in principle be a change of position defence.
Does that not go to the fundamental of reliance and anticipatory reliance? Because in any such case, there is a choice.
Well, it's not just the fact that there's a choice, but here the choice meant that the bank was taking the risk of non-payment.
But
That's our...
But isn't that inherent in any anticipatory reliance case? You're changing, you are doing something in anticipation of a receipt in this case.
And that may be said in the Goss case. The defendant was taking the risk that he might not be able to. He's taking a choice to pay out Mr. Hack in the circumstances there, but ultimately, and this is where risk-taking comes in, there has to be a decision, and it's language which is used, and it's a concept which is used in both Goss and Haugesund. There has to be a decision about who is going to be responsible where the choice is made for the loss which has occurred. In our submission, following on from the analysis and from the judgment, the first submission is that there plainly are circumstances in which the change of position defence will not be allowed where a party has made a payment, which on a but-for basis he wouldn't have made. And that's really directed towards paragraph 413 of the judgment. The second point is that it's the point I've just made, which is that if the defendant does take the risk in using the monies which he has received, in this case the banks uses the monies which he has received, there may be no change of position defence, and that's Goss and Haugesund. Thirdly, the principle is either causation or not unjust. Fourthly, the background here in our submissions that's relevant is that Venice didn't know on what terms the back-to-back hedging would take place or had taken place. It didn't request that. Objectively, it could foresee that it could well happen. Secondly, the banks decided to get the outwards protection. They decided whether or not they needed it, they decided the terms, they decided the extent.
But the other party doesn't have to know how the defendant has changed its position. I mean, what one's looking at is ex post facto, has the defendant changed its position?
Yes.
There's no answer to, if all the other ingredients of change of position are established, there's no answer to say, well, either claimant didn't know about what you were proposing to do.
It isn't a complete answer, but it's part of...
It's not an answer at all, is it?
Oh, my
What's
lord,
the relevance of it?
It's part of the question who took the risk of the non-payment.
The judge's finding is that it was objectively foreseeable that
Yes.
they entered into these hedging swaps. So that insofar as what your clients may or may not have known is of any relevance, that's a complete answer to it.
My lord,
If they thought about it at all, it was objectively foreseeable.
I'm absolutely not taking issue with that, my lord.
Right. Okay.
My lord, the third point we rely on in the background is if in this case the inward swaps being void, rates move such that the banks in fact become in the money on the outward swaps and receive payments under them. Those payments will be received beneficially by the bank. In other words, they will take the profit from the outwards protections. And I'm still, and the fourth point about the background is that the banks knew when they obtained the outward swaps that there could be...
But if the banks are in the money on the outward swaps, then the restitution claim just doesn't arise because Venice has made a profit.
my lord, that factually is right, but it's relevant to here to see who it is who's taking the risk of the non-payment in my submission, because it shows the extent to which this is really, these outwards transactions are really for the account of the bank. So it is relevant to the decision that the judge had to make as to who took the risk of non-payment. To look at, well, if there was a profit, who would take profit? In the circumstances where the swap is void. And the fourth point about the background is the one I've made earlier, but I've just listed it here, which is that the banks knew that there could be various reasons why the inward swaps didn't yield payment.
Sorry, various reasons why.
The inward swaps, which were the motive for obtaining the outward swaps, didn't in fact lead to payment to the banks. There's the credit risk. There's the risk of some supervening illegality, possibly. And there's the risk of the swaps being void for lack of capacity. Now, against that background, you then come to the question, well, in this case, did the bank take the risks here such that they ought not to be able to rely on the change of position defence in relation to the payments that they have received? And apart from the point about the bank having decided, secondly, they could foresee that there could be reasons why they might end up having to meet any obligations on the outwards swaps without receiving payments on the inward swaps. That's objectively plainly foreseeable and something that they knew at the time when they decided. Thirdly, they could control the terms. And
Why is it more likely that the bank should foresee that they would be exposed and that they would be advised, if they thought about it, that they'd have a change of position defence?
Well, the advice in my submission would have to be, well, you ought to take precautions against that possibility. And it's not just legal advice, it would be just commercial advice. If you're worried about the inward swap not being enforceable because you've noticed other cases, say, or just your experience on either from Italy or elsewhere, then commercially and legally you might be well advised to say, well, we're going to have either we're not going to get outwards protection, or if we do, we're going to make sure it includes terms that protect us. If that happens, like we would seek protection against the terms of the inward swap. And of course, either of those
things. Keep this money in our safe because we might have to pay it back one day.
Well,
Which would rather stultify financial business.
stultifying, yes. But of course, then you're running the risk that you have to pay out on the inwards. All these are possibilities. My point is, well, they're foreseeable. And the bank was in the driving seat there and made the choice, not just to obtain cover, but on what terms. And the fourth point is that, as I've made already, which is that they would take the profits if it did turn out that the inward swap was void and they had not negotiated terms that meant that they were able to and had terminated the outwards. And it turned out that the outwards was profitable. My Lord, finally, just 2 points briefly in relation to what Melenda Friend has said. Firstly, Melenda Friend's first point is about risk-taking as a useful concept. And Melenda Friend refers to a case called Barton, which you'll see in her skeleton, which in that case, which was not at all about restitution or change of position, criticises the whole notion of risk-taking. All I say about that is we can see Lord Gough and Lord Justice Aikens both utilise it in this context of change of position as a defence to restitution. And so it seems to me it's impossible to say that it's not an appropriate concept to apply. My learned friend makes various points in relation to Goss, and I've made my submissions on that, but just to underline that in our submission, in this case, the banks knew they had to pay under the hedge swap, whether or not the inward swap was valid. And that was equally true in Goss. The defendants there knew they had to pay on the mortgage whether or not the related party paid as he was supposed to do. My lords, those are my submissions on this.
Thank you very much, Scott. Yes.
My lord, the target of my learned friend's appeal is the judge's finding that the banks are entitled to a change of position. And he seeks to avoid that defence in two ways, which you've heard. The first is claiming that the restitution claim is governed by Italian law. And the second is by saying that there is a special rule of English law which precludes the banks from relying on a change of position, which would otherwise be made out on the facts. And we suggest that the judge was right to dismiss both arguments, and the criticisms made, particularly on applicable law, of the judgment are not justified when one considers how clear the test was the judge had to apply. So can I start with the first ground of appeal? The contracts, as you know, were entered into at a time when choice of law for obligations to make restitution was governed by common law. And it's common ground between the parties that this meant the judge was required to consider which law had the closest and most real connection, which is often described in the authorities as the proper law. And Venice sets that out in its skeleton at paragraph 12, so you can be sure it's common ground. The judge applied that test, and he found that the restitution claim was governed by English law because of the choice of law of English law in the Venice Master Agreement. And that is in his judgment at paragraph 390. And we suggest that was plainly the right conclusion for three reasons. The first is that the parties chose English law, not Italian law, as the governing law of their contracts. The second reason is that under Article 8.1 of the Rome Convention, English law was applied for the purposes of determining whether the contracts were void. And in particular, under the approach in Haggersund, it was English law, not Italian law, that governed the correct characterisation of Cattolica and the consequences of a finding that the transactions were beyond Venice's capacity. Thirdly, there is a very close and real connection between the law that determines whether the transactions are void and the law that determines what claims can be brought as a result of a finding that the transactions are void. Applying the same law produces a logically and legally coherent result. It is consistent with the reasonable expectations of the parties, and it has significant practical advantages. And on my learned friend's case, the court ought to have switched from English law to Italian law simply for the purposes of determining the legal consequences of a finding that the transactions were void.
As a matter of English law.
Exactly. And it just makes no sense. Can I turn up the judge's reasoning, please, my lord, on the point? And it was set out in paragraphs 390 to 392. I don't shy away from the fact that it was shortly reasoned, but I think that's, in my submission, because the point was actually relatively clear-cut. And we make 4 points about the judge's reasoning, but perhaps I'll let you read the paragraphs first, and then I can make the 4 points. You were shown them yesterday, so I'm sure they're familiar.
Yeah.
So the 4 general points are, first of all, you can see the judge applied the correct legal test. He applied the closest and most real connection test. So there is no question of him having applied the wrong legal test and having erred in law. Secondly, he was not purporting to establish a general rule applicable in all cases. He was expressing a view about this case. He uses the words this case. Thirdly, the judge gave the most weight to the choice of law clause in the Venice Master Agreement and gave detailed reasons for having reached that conclusion. And fourthly, it is unreal to suggest that the judge somehow overlooked other connections with Italy that were relied upon by Venice below. I don't need to remind this court of the presumption that such matters have been taken into account by the trial judge. They were put front and centre of Venice's pleadings and submissions below, and he had only in the prior paragraph quoted in full the judgment of Mrs. Justice Cockerell engaging in the very exercise. So with that in mind, may I make some brief points about the approach that this court should take on appeal relating to a first instance judge's application of the common law test. And in our submission, when determining what is the closest and most real connection, that is quintessentially a matter for the commercial court judge. And the court should only intervene, this court should only intervene, if the judge made an error of principle or the decision was plainly wrong in the relevant sense, which it wasn't. And in support of that submission, we've given references at paragraph 11 of our skeleton to 2 decisions of the Court of Appeal, which were concerned with appeals against the choice of law under Section 11 of the Private International Law Miscellaneous Provisions Act 1995. I don't need to turn those up.
Sorry, Mr. Laney, just remind myself what you said.
Of course.
Paragraph 11.
Paragraph 11. And it's the door knock,
Yeah.
by way of example, the door knock Mauritius case.
Yeah, it's Alliance Bank.
Exactly. And in both cases, the suggestion that the judge's assessment should be a challenge, was given short shrift. And we say, in this case, given the judge applied the correct evaluative test, the court should not interfere. But in any case, we say that he was correct both as a matter of principle and precedent.
Yeah.
So may I then turn to the substance of ground 1 and the principled reasons for applying English law. And it's common ground that there is no binding appellate authority to have considered the application of the common law test on similar facts. So it's helpful to begin by looking at matters from first principles. And we suggest that there are 5 reasons why the putative governing law of the contract should also govern a restitution claim arising out of the invalidity of that contract in a case like this one. So first of all, it's by reason of the close connection. And there is a very close connection between the law that governs the invalidity of the contract and the subsequent restitution claim, because the restitution claim arises directly from that invalidity. And that was the point made by the judge at paragraphs 390, little Roman 1 to little Roman 4, which I've shown the court, and a point that I know that the court has. And in our skeleton argument, we quote the article from the article of Joanna Bird. And could I ask you to look at the quotation? It's at page 145 of the core bundle, tab 6, paragraph 14 of our skeleton. And in our submission, the point being made by the author in that paragraph is a very powerful one. The restitution claim only arises because the contract is void. And as the court will know, there can have been no restitution claim if the contract had been valid, because the relevant benefit would have been conferred pursuant to the binding contractual obligation. So, in those circumstances, to require the benefit to be repaid would undermine the contract. Now, in this case, English law was applied for the purposes of deciding whether the contract was void. We accept that Italian law was applied for certain purposes in connection with that argument, but under the approach of Haggersund, English law determined how those Italian laws should be characterised, and English law decided the consequences of a lack of capacity. So, on the assumption that the Italian rules are properly to be characterised as going to Venice's capacity, it would then have been irrelevant if Italian law had then nevertheless upheld the bargain. For example, the good faith point. And your Lordship will recall that this was the position under Norwegian law in Haggersund itself.
Well, that was the point on which Lord Justice Etherton
Exactly. And that's why he dissented. Exactly.
The case never went to the House of Lords or the Supreme Court.
It didn't. It didn't. But Mr Justice Tomlinson, who was upheld on this point by the Court of Appeal, said it wasn't relevant as a matter of English law because it wasn't properly to be characterised as a rule relating to the commune's powers. And it could have led to the paradox that a transaction held to be invalid under English law would nevertheless have been upheld in Norwegian law, but one never got to that debate. So the point is that the close connection arises because English law determines whether the contract is void and the consequences, notwithstanding what Italian law would have done. And of course, my learned friends seek to take advantage of that point in that case. So that's why we talk about the close connection. My second of my 5 points is that there are a number of other contexts where the putative governing law of a contract applies notwithstanding a dispute about the validity of the contract. And we've gathered together the references in paragraph 16 of our skeleton argument. The short point we make is that since 1991, when the Rome Convention was signed, almost all EU nations applied the putative governing law to a restitution claim arising out of the invalidity of a contract. And since the 17th of December 2009, when Rome I came into effect, this has also been the position under English law. So if the contract had been signed 2 years later, we wouldn't be having this debate. English law would clearly have applied. In those circumstances, it is relevant for this court to have in mind that the approach that Venice urges upon you would result in English law being out of step with the approach that has long been taken in many other jurisdictions and in this jurisdiction today. The third point is legal coherence. Applying English law to the restitution claim is more likely to produce a legally coherent result, because it is artificial to separate out the validity of the contract from the consequences that flow from finding that it is invalid. Put another way, the two issues are part of a single problem, and the legal rules governing both issues have been designed to dovetail with one another. And can I refer you again to another quotation of from Joanna Bird's article, which we set out in paragraph 22 of our skeleton argument at page 147 of the bundle. And the present case is a good example. English law attaches a premium to the sanctity of contracts. English law recognises that people are entitled to conduct themselves on the basis that their contracts will be upheld. And that important policy concern applies not only when attempting to enforce the contract, but also when dealing with the consequences of the contract being invalid. And in particular, English law recognises that one party's position may have changed in reliance upon the belief that the contract was valid, and then one has the change of position defence. And that is what the judge was referring to in paragraph 390 little Roman 4 of his judgment as security of receipt, and is why the change of position defence is so important under English law. So switching suddenly to Italian law for the purposes of the restitution claim, we suggest would drive a coach and horses through the balance, as it's put, the internal balance of English law by removing the security of receipt from the equation at the restitution stage. And it would deprive the banks of one of the key protections under English law against the otherwise damaging consequences of unwinding a contract that was performed for a very substantial period of time. The fourth point, my lord, is expectations. As the judge observed in paragraph 390 little Roman 6 of his judgment, applying English law is consistent with the parties' expectations when they entered into the contract. Now, of course, the parties did not expect their contract to be held to be void, but it is inconceivable that they would have expected any other law to apply in that eventuality, and unreal, we suggest, to close one's eyes to the fact that they thought about which law would apply to the contract and chose English law. And Venice's position is that the party's choice of English law should be discarded because the contract is void. But there are two answers to that. The first is that even if the choice of law clause were held to be invalid, it remains the case that the parties intended English law to apply, and that fact cannot be denied. And notably, the Rome Convention does not require a choice of law clause to be binding in accordance with domestic principles of contractual construction. And we set out that point in paragraph 29(4)(c) of our skeleton. So we say the judge therefore rightly attached weight to the party's choice of law, irrespective of whether the choice had contractual force. The second point, though, is that the choice of law clause was not invalid. And it may not be necessary to get into this, given my first point, and the point was not addressed by my learned friend, but a choice of law clause is severable in the same way as a jurisdiction clause is. And both types of clauses, jurisdiction clauses and choice of law clauses, are intended to be independent agreements which apply irrespective of a challenge to the validity of a contract. And the jurisdiction clause tells us which court has the power to decide the dispute. The choice of law clause tells us which law is to be applied for the purpose of resolution of the dispute.
I can't remember now whether the provision is a combined jurisdiction and choice of law clause under the ISDA Master.
Often they are, and I think it is. I think it is here.
So it's both.
It is.
Because
And
the whole clause is severable.
and we rely, if we need to, on the Enker and
I
Chubb
was going to say,
case.
one thing about Anchor that isn't controversial.
That's right. So, and there's some discussion of the point, I think, in the judgment at 391 to 392 of the judgment below, and the relevant paragraph of,
Simply says scope for debate.
that's right, but the relevant paragraph of Enker, if your lordships want it for your note, is paragraph 53, sub-Roman 5, which is one of the reasons to apply the choice of law for the contract as a whole to the arbitration clause in Enker was that it aligned the approach to arbitration agreements with choice of court and choice of law clauses, which are, I quote, insulated from challenges to the contract. So it may not be necessary to rely on that, but we offer that as a second reason why the judge took the right approach. And then that brings me to my fifth and final reason for applying English law, which is pragmatism. The obvious point we make is that the judge's approach has the benefit of certainty and avoids the scope for applying multiple different laws to interrelated issues. And Venice, in fact, admits in its skeleton argument at paragraph 42 that it is, quote, desirable in principle to have a single governing law. Venice also accepts that sometimes a choice of law rule can be driven as much by pragmatism as principle, and that is in its skeleton argument at paragraph 40. So it's unclear to us why those practical considerations should go out of the window when it comes to choosing the governing law of the restitution claim. So, my lord, those are the 5 points of principle. Can I now turn briefly to the authorities?
The result of your points of principle, if we accept those, is that in almost any case, the choice of law is going to be determinative. Thinking of the boxes in the appellant's skeleton. So perhaps in exceptional cases, there's not going to be a great deal of evaluating to do. You simply look and see it was an English law contract, and that gets you home. You don't shy away from it.
I don't, and that's why I say the judge's judgment was so short, because I think he took that approach, and I think he was right to do so. The only case that seems to take a different approach is Prato, and in Prato there was a slightly different circumstance in that Italian mandatory rules applied, so that it can be distinguished. But otherwise, the choice of governing law is, we suggest, the starting and the end point, but for the 5 principled reasons I've suggested.
So this is a rather firmer view than Mrs. Justice Cockerill's in Busto, for example.
I think it may be that I've got firmer as time has gone on, my lord. My lord, the authorities, we say,
You're
don't take.
entitled to refine your argument.
Indeed, they get better and better, my lord, clearly. My lord, the authorities don't actually take matters very far because there is no appellate authority to have considered this point. But there is authority.
Well, it's Prato at first instance.
At first instance.
Which isn't the point isn't dealt with in the court.
No,
And the judge in that case really goes to the other extreme.
he does. And as I say, it's distinguishable because in that case, Italian
It's
mandatory.
sustainable as in other cases.
That's right. But what we suggest, though, is such authority as there is actually supports the judge's approach. So when Venice says that there is a weight of authority against the judge's approach in its skeleton, paragraph 34, we don't accept that. So can I start, and I can take this reasonably quickly, but if I may start with Dicey and Morris Rule 230, and that's in the Authorities Bundle, volume 15 at tab 119. This is the 14th edition, as you know, because subsequent editions focused on the law under Rome I, which favours the putative governing law.
Sorry, give me the reference again.
It's tab 119 of the Authorities Bundle, and it's volume 15.
Yeah.
Do you have a page number?
It's 6151 hard copy and 6157 in electronic.
This is two.
And the reason we start here is because the authorities have tended to, it's Rule 230 it starts.
231.
Exactly. Now, Rule 231 is the obligation to restore the benefit and enrichment obtained at another person's expense is governed by the proper law of the obligation. And the commentary explains what is meant by the test of most closely connected. And it's important to be clear that this is the rule, little 1, that's intended to be applied flexibly across restitution cases. Rule 232A is guidance intended to assist in applying that flexible general rule. And the only reason I flag that is at times it appeared to be suggested in Venice's submissions that it was Rule 232A that was itself intended to be applied flexibly. And we say that's not actually correct. And if one needed any authority for that proposition, it's the Ugraneft case. Standing back, looking at Rule 232A, it provides that the governing law of the restitution claim will usually be the governing law of the contract, but of course this is not inflexible. And you can see the commentary over the page at 34-020. It's right at the bottom of the page.
Yeah.
And then if one goes over to paragraph 34-023, and if you just read the first paragraph.
There, Dicey makes precisely the point the judge makes in subparagraph Roman 6 about what the parties would have expected if they turned their minds to it.
Exactly. And then if we go over, I should show you for completeness, 34-028.
So 34.
-028. Now, much reliance, I think, was placed yesterday on Arab and Hashim. So may I just go back to that case briefly? It's in the authorities bundle at tab 24. And it's page 820, hard copy 826 in soft.
Time.
24, my lord.
So that's the first instance decision.
That's right. This is Mr Justice Evans. And as my lord, Lord Justice Mayles noted yesterday, the case concerns bribes that were paid to the claimant's agent, Dr Hashim. The claimant sought to recover the bribe from Dr Hashim, and the agency contract was governed by the law of Abu Dhabi. The bribes were paid pursuant to an agreement made in England, and they were also paid from an English account to a Swiss account. The claimants alleged that the claim for bribery was therefore governed by English law, and Mr Justice Evans disagreed. He held that the bribery claim was governed by the law of Abu
The
Dhabi.
effect of that was there wasn't actually a claim at all,
Exactly.
because there wasn't a tort of bribery or Dhabi law.
That's right. That's right. But if we could look at...
Quite a stark case on the facts.
It was quite a stark place. But the point was that... Sorry, I'm just getting one moment. The point, though, is that I want to show you is the flexibility of Rule 232A that Mr Justice Evans recognised, which I don't think was put to you yesterday. And if you could look at 8.4... get the right reference, 842 of the bundle, which is 848, please, electronically. And it's the bottom right-hand column, the very last paragraph, an obvious case where.
Yeah.
If you read that first paragraph, an obvious case,
Yeah.
and then if one could go over the page to the bottom left-hand paragraph, in my judgment, however, I'm clear that they are both within sub-rule 2A. But he says he prefers to base this conclusion on wider grounds.
Yeah.
And so that's why Dicey and Morris refers to the tension between that case and the Barings brother case, the Scottish case. But contrary to the submission made to you yesterday, my learned friend suggested that there was no judicial support for Lim 2A, but there is, and this shows it. It may be that the judge based his conclusion on wider grounds, but one can see his reasoning. Now, this, of course, was not a void contract, but I'm just showing you the 230A point. If we then look at the Court of Appeal decision, which is in tab 28, please, of the authorities bundle. And that is page 1017 in soft copy. And if you could please go to, in the internal law report 597 or 1025 of the electronic bundle reference. And you can see at the very bottom left-hand corner, as a matter of English law, that paragraph, and you, if you go just above, sorry, much the same considerations apply to the claim in quasi-contract. If one goes over to the first paragraph on the right-hand side as well. If I could then turn up again the Barings Brothers Scottish case, which my learned friend relied on, which is in volume 13, tab 97. And it is 5314 of the electronic bundle. 5314. And we suggest that this was the high point, I think, of my own friend's submissions, but it doesn't, we say, lend very much support. Your Lordship will remember it's a decision of the Court of Sessions in Scotland. It's therefore wasn't binding on Mr Justice Foxton, it's not binding on this court. And it arose out of a forward rate agreement, which was...
effectively a decision of a judge of first instance.
It is.
In a parallel jurisdiction at the same level as Mr Justice Foxton.
Exactly. And it concerned a forward rate agreement which was ultra vires and therefore void. A question arose at an interlocutory stage as to whether there should be a full trial or merely a disposal on the point of law. And that turned upon whether English law arguably applied, because the banks are out of the money under what had emerged to be a void swap and claimed restitution. The local authority said the claim was governed by Scots law and that it was time-barred under Scots law. The bank said it was governed by English law and it wasn't time-barred. And the banks relied on the putative English law, choice of English law in the void contract, and said that it meant that either it applied or there needed to be a trial to work out whether it did apply. And Lord Penrose held that the case needed to proceed to a trial so that the applicable law question could be decided on the evidence. The judgment with respect isn't the easiest to follow, but as we saw yesterday when my learned friend showed you the authority, Lord Penrose considered that the putative choice of law was relevant and material, and that was the only question he needed to consider in the circumstances. Now, I don't think that my learned friend is now pursuing the extreme case that the choice of law is anything but relevant material. And once it's accepted that the choice of law clause is relevant and material, using that phrase, then it is undoubtedly for the trial judge to decide whether to give it decisive weight in the final analysis. And there can be no room for a legal rule which says that it never can be decisive. And we suggest Lord Penrose was not trying to lay down any such rule. And if you want to see the relevant material as the case is open, it's at 5326 of the hard copy and 5332 of the electronic.
Has anybody found out what did happen to the case when it went to trial?
Not that I can answer, madam, I can check. We're told we don't think it went to trial.
That's a surprise.
So, my lord, that deals with that case, and then Prato I have raised with you, which is distinguishable on the basis that the judge found that there were mandatory rules of Italian law, which takes it into a different spectrum to the extent one needs to follow it in any event. And you've also seen the obiter observations of Mrs Justice Cockerell. So those are the authorities.
Although you say that once the putative proper law is held to be relevant and material, it's a matter for the trial judge
Exactly.
how much weight to give it. You also submitted earlier, as I understood you, that usually it should be given decisive weight.
Yes.
So, in other words, a trial judge on your case who doesn't want to give it decisive weight has got to give some pretty convincing reasons why that should be so. Is that a fair summary of your
It is.
submission?
It is.
Yes.
So my submission would focus on the latter point, first and foremost, but in answer to my learned friend's case, even he has to accept on the basis of the authority he puts his stall on, set a stall by, that it's a relevant and if not decisive factor, but once it's a relevant factor, it's a matter for the trial judge.
When you say that, so far as the criticism that Mr Cox levelled at the judge yesterday, that he hadn't balanced the various Italian factors, you say, well, that's just unreal because he clearly must have had them in mind. See the fact that he just finished talking about what Mrs Justice Cockerell had said
Exactly.
about the Italian factors.
Exactly. And also I do note that it wasn't very clear from my learned friend's submissions yesterday quite which of those Italian factors were still in play and what he was pursuing. So that didn't
But it was a
come out.
mandate agreement, I think.
Right.
Well, I don't think he was able to say whether it was still of any relevance or
Exactly.
even in force.
Exactly. And it seemed to come down to yesterday the fact that parties were located in Italy. Well, that's not a very compelling factor in my
And
respect
the
submission.
contract was performed in Italy where all the payments were made and so forth. There's quite a lot of factors you can put together.
The unjust enrichment took place in Italy.
Indeed.
That's
Indeed. But, my lord, we suggest that those factors will have been in the judge's mind given what he had just said. Secondly, that obviously they don't outweigh the choice of putative contract, as I've said. But thirdly, with no disrespect, the range of factors wasn't even clearly articulated yesterday. So the judge might be forgiven for not articulating them all in the relevant paragraph, but having in mind the points that had been generally made as he went along.
I thought your earlier point, and perhaps a stronger point, is that they were front and centre, and therefore the judge can't have overlooked them.
Well, they were front and centre in the arguments on the background to the case, because obviously they were part of the facts, and that's my point. So, my lord, what we would say is...
well. Then the other thing which is interesting, because this is a point that occurred to me when Mr Cox was making his submission yesterday. If you go back just 2 paragraphs to 388, where the judge deals with Dexia, and he actually says what Mr Justice Walker held on very similar facts to the present case. So the suggestion that he somehow has overlooked the Italian law, the factors pointing to Italian law, is, as you put it earlier on, pretty unreal.
Indeed, my lord.
Yeah.
So, my lord, I was just going to make the 3 points by way of conclusion, but I think your lordship has them. That there's no principal basis for saying that the putative choice of law should be legally irrelevant, and no authority to support that proposition other than possibly Prato, which I've dealt with. Secondly, there's no credible basis for the suggestion the judge simply overlooked the connecting factors on which Venice relied. And thirdly, as I've debated with my Lord Justice Mayles, the decision to attribute most weight to the putative governing law was plainly correct, and therefore the appeal should be dismissed. It remains for me very briefly to deal with the other connecting factors which have just been raised. And it's only relevant, of course, if the court concludes that there was an error in the judge's approach, such that it's necessary for this court to reassess which law has the most real and closest connection. And you have my point on the putative law. There are other factors which connect the restitution claim with English law, namely the hedging swaps were all governed by English law, and these agreements are most closely connected with the swaps and provide the pleaded basis for the bank's change of position defence. And the swaps were entered into in connection with a broader restructuring of Venice's liabilities under the Rialto bond, and both the Bear Stearns swap and the amended Rialto bond were governed by English law. So there are those additional points. The factors relied on by Venice should be given very little weight, we suggest. First of all, the Italian law agreements all related to the period leading up to the conclusion of the transaction, the mandate agreement. And they had nothing to do with the benefits conferred under the transactions thereafter. Secondly, the place of enrichment and the domicile of the parties has very little to do with the substance of the obligation to make restitution in a case such as this one. What matters in this case is that the putative English law contracts under which payments were made were void, applying English law, so that's where the centre of gravity lies. And thirdly, the bank's regulatory duties under Italian law are also irrelevant concerning, again, the period before the parties entered into the contract, and were, in any case, they were inapplicable under Article 3.3 of the Rome Convention, and in any case, Venice's claim for breach of those duties failed. So, my lord, that I think addresses ground one, unless you have any further questions. That then takes me on to change of position, which is really the meat of this appeal. So may I start with the ultra vires argument? Now, Venice's original case was simply the one I'm going to outline. A new case was articulated yesterday by my learned friend Mr. Paul on his feet, his alternative case. And I will address it, but just to highlight, it was a new case, it's not in the skeleton. So Venice's case, which is now said to be its primary case, is that the change of position defence is never available in response to a claim to recover benefits conferred under a contract that is ultra vires. And you see that from paragraph 54 of Venice's skeleton. Now, just standing back, my lord, that argument has nothing to do with the fact that the change of position took the form of payments under the hedging swaps. Because on this argument, it wouldn't matter what form the change of position took. And really, it's quite a stark point, because on my learned friend's approach, there is simply no room for a change of position defence, whenever payments were made under an ultra vires contract. And a number of times yesterday, my learned friend submitted that change of position should be ruled out in an ultra vires case because the defence would stultify, and I quote, the policy rationale giving rise to the restitutionary claim in the first place. And that was at day 3 of the transcript, page 147, lines 15 to 20. Now, in my learned friend's submissions, he didn't identify the policy rationale underlying the right to restitution in the case before your lordship. Because, as the court will know all too well, where benefits are conferred under an ultra vires contract, there are a number of different unjust factors that can be relied upon. For example, in a tax context, as we were debating yesterday, the right to restitution may arise because of the Woolwich principle, and we saw that in the FII case yesterday. The policy rationale or justification giving rise to the right to restitution in those cases is that the government has levied a charge without statutory authority. And that engages important public policy considerations which have been held to override the change of position defence in that tax context. The present case is completely different. And in this case, as your lordship knows, Venice pleaded its claim on the basis of a mistake of law. And just to remind you, this is pleaded in paragraph 97d(1) of the reply to defence to counterclaim. I don't know if your lordship wishes to see that. It's in the core bundle at tab 19. Tab 19, page 512. That's where paragraph 97 starts, and if you go over the page then to little d, so you see the plea on mistake.
Yeah.
So in a mistake case, the policy justification giving rise to the right to restitution is the fact that the claimant's consent was vitiated by the relevant mistake. And here, of course, this is a private law claim. I think this is one of the points that my Lady Justice Falk was making yesterday. Now, in such cases, it's well established that a change of position defence is available. And just by way of these introductory remarks, one should also note from the paragraph I've just shown the court in the pleading that, of course, Venice deliberately pleaded its restitution claim on the basis of a mistake of law so that it could take advantage of, or try to take advantage of, Section 32(1)(c). So they can't really have their cake and eat it, because the House of Lords held in Claimants Benson, which we've seen and we'll come back to, that a claimant could bring a claim for mistake of law with the benefit of a potentially extended limitation period, but expressly on the basis that a change of position defence would provide a measure of historic protection. So it's not consistent, really, for my learned friends to take the stance that they are taking. And the judge did take a consistent approach because he held that Section 32(1)(c) was engaged, we say wrongly, but having done so, he held that the change of position defence applied.
So, just to sort of pause on that for a moment, the point you're making is that the basis of the restitution claim is the mistaken belief that they were liable to, that the contract was a valid contract.
Exactly.
So that I think what you're going to go on to submit is that the ultra vires principle, whatever that principle is, isn't engaged in those circumstances, because there are any number of reasons why the consent might have been vitiated by other contractual defences that might lead to the contract being void or voidable.
That's right. And similarly,
none of the authorities seeks to say, well, that somehow a restitutionary claim arising where the contract is ultra vires the local authority, ultra vires the party in question, is somehow has a different sort of quality to it. I mean, that's the point.
Exactly. Exactly.
It seems to me that you were, putting it in my words, saying that the availability of a restitutionary claim in a mistake of law case is essentially a package in which you get the availability of a claim, you get potentially the benefit of section 32 for in order to avoid limitation problems if you can bring yourself within it, but you also balance that by the availability of a change of position defence.
That's right.
That's my words, not yours, but is that effectively what you're saying?
It is, and I think it was Lord Hope who said that he took comfort from the fact that there was a change of position, maybe a change of position of defence
You can
available.
find statements to that effect, and I'm sure that's one of them, you say so.
Exactly.
Yes, okay.
So he certainly saw it as a package, I would too. And one can see why, because it would produce a manifestly unjust result on the facts of this case. Because Venice's contention is that the bank should be required to repay the full amount received under the swaps, which is about 72 million euros plus interest, whilst at the same time being required to bear their losses in a substantially equivalent amount. Obviously, the quantum isn't in dispute here, but that's their case, in a substantially equivalent amount under the hedging swaps, notwithstanding the very close causal link. And from an English law perspective, that would be quite strange, because the purpose of an unjust enrichment case is to restore the parties to their original position. So it's inconsistent with that purpose for a defendant to be required to make restitution if left worse off. And that's the whole point of the change of position defence. So the other point I would make on this is that not only is the result unjust, but my learned friend's case would require the court to uphold an incredibly broad principle, because I think it was my Lady Justice Falk yesterday at day 3, page 153 of the transcript, who observed it would mean that there could never be a change of position defence to benefits conferred under an ultra vires contract, no matter how the claim is framed. Now, this morning, I think having thought about those comments overnight, my learned friend accepted that, and he sought to draw some sort of distinction between the public and the private law context. And I'll come on to this. The problem for him with his case is that he doesn't rely on any Italian public policy. So on facts, even if that distinction was right, it doesn't help him on the facts of this case. And the other point to have in mind is that if my learned friend's submissions were accepted, then there would be quite a number of cases that were wrongly decided or had proceeded on a totally false premise.
Yeah.
The other point finally on this, just to tell your lordship, is that this case, this very extreme case, in whatever guise it may be now being advanced, as a little less extreme this morning, was not run before the judge. On the contrary, Venice accepted that there was no principled objection to change of position in an ultra vires case. And I can show you that in a moment. And then, my lord, yesterday, Mr. Paul referred to his primary case, and he then referred to an alternative case that change of position is not available where the change of position occurs before receipt of payments under the swap. This was the anticipatory case. Now, the alternative case, I don't think is advanced. I'll be corrected, but I don't think is advanced in Venice's skeleton. Flag that. I'm happy to deal with it. It's wrong, but I should just flag it's not dealt with in their skeleton argument. And then in a nutshell, the reasons why it's wrong is once it's accepted that there's no principled objection to a change of position in an ultra vires case, it can't be correct that the availability of the defence turns on the sequencing between the change of position on the one hand and the date when the benefit is received on the other. That would just be
Well,
unreal.
if anticipatory reliance is an available point, which it is, then it's difficult to see what principal distinction there is between the two situations.
I agree.
Simple as that.
I agree. As I say, it would come down to a timing point.
Mr. Cox has got a sort of different point about risk-taking in relation
Yes,
to
that's a different ground, I
the
think.
Hop House decision, but leaving that to one side, it's difficult to see what distinction there is.
We agree.
Okay.
So, my lord, just before lunch, shall I outline the relevant legal principles?
Yes.
And then I'll come on to the cases after lunch. So the first point is that there is no rule which precludes a change of position defence in every ultra vires case. And there cannot be, because there would be a wealth of inconsistent authorities wrongly decided if that was right on my learned friend's view of the world. Secondly, there is a principle which rules out the change of position defence wherever the defence would stultify the policy which underlines the claimant's right to restitution. And this is what is referred to as the stultification principle. But thirdly, there is no room for the application of that principle in this case. Because as I've already said, this is a private law claim based on vitiated consent, and there is no principled reason why Venice's mistake should override the bank's right to security of receipt. And what I'm going to do to make those points good is to structure my submissions under the following topics. First of all, I'm going to look at the cases on stultification to explain what the principle is and why it doesn't apply in this case. Secondly, I will address, but briefly I think, the extreme case of change of position doesn't apply in any ultra vires situation. And then thirdly, I'll deal with the new fallback alternative case. So my lord, I'm happy to move to one of the authorities now, or to wait till after lunch, as you wish.
We're making good progress.
Yes, I think so.
Good. Okay, 2 o'clock then. Hopefully we'll have real time at 2 o'clock.
I hope so. We'll find out.
Court rise.